Hello, all. Welcome to this new session of our course titled Legal Essentials for Human Resource Management. Now, this is week one, and we are at the final session of this week, which is the session 5. If you remember our last session, we were looking at the definition of the term industry, and we brushed aside through this term called as employer. In today's session, we will look in detail certain terms like worker, employee, and we look into a little bit of interpretation and new age definitions of the term employer. So without much delay, let's get into the session 5 of week 1. As you know, my name is Dr. Amish Samalopanan and I am from Nalsa University of Law. Now, who is a worker and why is it important that we define who is a worker? It is very important because until you define who is a worker, they cannot demand certain provisions under industrial dispute, because provisions in the industrial dispute is reserved for workers. There are certain legally targeted protections and privileges for trade unions. Until you don't know if you're a worker, we cannot see if these provisions apply for you. And hence, it's very important for you to understand whether this person is a worker or not. Let's see what is the definition according to Industrial Dispute Act. Now, the section 2(s) of Industrial Dispute Act defines workman. So at that time, it was not the term worker; it was more a general, rather a gendered term called workman. And the definition broadly included anyone who's employed in an industry to do manual, unskilled, skilled, technical, operational, clerical, or supervisory work for hire or reward. So the definition included it has to be for one from industry. So you would be a person who is working in an establishment that comes under the definition of the industry, which we have seen in the last video. If you have not seen it, I request you to go back to the previous video, session 4, and come to a conclusion or understanding of what the word industry is. And the establishment falls under the category of industry, and you are somebody who is doing a manual, unskilled, skilled, technical, operational, clerical, or supervisory work for hire or reward. Now, there are certain exclusions here. If you are a managerial or administrative staff, you can't be called a worker. And if you are a supervisory staff, supervisory positions are included in the definition of worker. But if you are somebody who is drawing a salary above 10,000 rupees a month, or if you are a supervisor with managerial powers, then you will not be called a worker. And of course, members of armed forces, police, and prison services are also not called as workers. Now, this is a definition of the term worker. So, if you see, there are two key elements. One, there is a wage ceiling. Second, especially if you're doing a supervisory position. And second, do you have a managerial or administrative position? So, you should not have power in terms of financial or managerial position, and you should be working within the ambit of the industry. So, two things are very important in deciding if you are a worker or not. Even though the definition looks very clear, there were a lot of debates over it. For example, the case HR Adyananta versus Sandoz India Limited in 1994 ruled that medical representatives are not workmen under IDA Act. So if you are somebody who is involved in promotion of sales, the court ruled that you can't be called as a worker because you are not involved in the industrious work of a traditional definition of industrial work. You are rather doing a sales and promotion work, hence you are not a worker. Now, as we discussed in the previous session, an industrial relations code is in picture. Now this industrial relation code have consolidated various laws which include the Trade Unions Act, Standing Orders Act and Industrial Dispute Act. So the IRC, the Industrial Relations Code, one good thing they have done is they have replaced this term workman with worker. So it's no longer a unigender term, but it is a very it is a overarching, all-encompassing term which is worker. And under section 2(ZI) of the IR code, a worker means any person employed in the industry. So that's exactly the same definition that we had before. It has to work in industry to do any manual, unskilled, skilled, technical, operational or clerical work, more or less on the same line of the previous definition, for hire or reward, whether the terms are expressed or implied. If you go back, it was not defined there. This idea that the terms are expressed clearly was something that was not covered before, and often that used to be an area of confusion. But the newer definitions clearly states whether the terms are expressed or implied also, you come under the ambit of workman. Of course, there are certain exclusions. For example, if you are employed in managerial or administrative capacity, exactly what previous definition also said, and supervisory capacity drawing wage above a specific threshold, these numbers keep changing. So the code sets 18,000 per month as the threshold. The previous definition there was 16,000, that also came in later in 2014-15 duration. It was 1,600 before. So as the value of money keeps increasing, these rates are revised. And of course, like the previous definition, military, police and prison personnel are also excluded. What has been included apart from the previous one is first working journalist and sales promotion employees. Now previous definitions of the court judgment have excluded these two categories from the traditional definition of workman, but the newer code includes these two. And IR code for the first time clarifies who is apprentice and not. So it says apprentices, not workers, for the purposes of industrial dispute. And why is it that? I mean, I teach this in my classrooms, and students, they go for internships and as apprentices. And they say that, sir, isn't it unfair that we are not given the protection of workers? The idea is that all this apprentice training, all this internship training are much required for them to upskill themselves. Now, you should not discourage an employer by giving those opportunities to younger generation by putting them under the ambit of legal complications. We should not discourage an employer saying, oh, you have to bring them also under social security regulations, you have to bring them under these protections. They can be part of organizations. And so it is kept very clear, if you are an apprentice, you are not worker. Now the second term, employee. Please do understand, an employee and worker, not exactly the same thing. Employee is a larger word. Worker is a subset in it. And you're not worker doesn't mean that you're not liable for some of the social security protection or employment protection. So let's see how employee is been defined in the IR code. However, if you look at the Industrial Relations Code of 2020, it defines employee according to its section 2L as any person who's not an apprentice and is employed by an industrial establishment. So that condition doesn't change. It has to be an industrial establishment to do any skilled, semi-skilled, unskilled, manual, operational, supervisory, managerial, administrative, technical or clerical work, which means the all kind of works are now included for hire or reward, whether the terms of employment be expressed or implied. So the terms of employment, is it expressed explicitly or not, doesn't matter. And also include a person declared to be an employee by the appropriate government, so government owned or rather authoritative industries, but does not include any member of the armed forces of the union. So the term employee is a much more broader term, which of course includes all the workers. It excludes members of the armed forces as well as apprentices. So it's a very broad term. Let's see how employer is being defined. We had looked into the definition in the last session. Let's just quickly look into a little more details of it. So as you know that section 2G of Industrial Dispute Act is what defines employer. And if it is a government department, so authority prescribed in this behalf is the employer. And when there is no authority is prescribed, head of the department becomes the authority. Now, to give you an example, if there is a dispute involving government run enterprise, like let's say railway, it's not the railway minister who is the employer. That's what the definition is saying. It's the authority prescribed in this behalf. So probably a secretary or a director would become the authority of that particular department. And if there is no proper mention of who is the authority, the head of the department. When it comes to local authorities, the employer is the chief executive officer of the authority, like municipal commissioner or equivalent people. Now, when it comes to private enterprises, which is more interesting, the person who has ultimate control over the establishment's affair and where the affairs are entrusted to a manager or managing director, that manager or MD is the employer. So either it's the person who has ultimate control over the establishment's affair, he is the principal employer. Let's say there is a managing director appointed to take care of day-to-day activities. It's the managing director who is the employer. So you cannot go behind the owner when there is a dispute. It has to be the managing director because he is the employer. There were certain judicial clarifications in the term employer. If you look at industrial disputes or industrial aspects, it's a triangular relationship. So there is employee or worker, there is an owner or an authority who has control over the establishment, and there is government. So general conditions, these is three parties involved. But what if the primary employer decided to have contract workers through a contractor? I own a hospital. To clean it, I didn't want to directly hire employees, so I have entrusted this with a cleaning solutions company. So they bring in their own employees to clean. I just pay a lump sum amount to the contractor, cleaning contractor, who has taken over this job. Let's say in such a scenario, who's the real employer of that particular employee or worker who has come in to clean or to oversee the cleaning process? Is it me, whose hospital or establishment it is, or is it the contractor? Because at the end of the day, it's the contractor who's paying the money to these employees. So this was an issue that came in Hussain Bai versus Alat Factory Trilali Union, and the court ruled that the principal employer cannot escape the status of employer by interposing a contractor. So the court clearly said that while contractor might have a primary responsibility, principal employer cannot escape the status of the employer also. So if the contractor is not doing his duty as an employer, the principal employer has to intervene and ensure that the duties are performed. So what court observed is that the real employer is the person who has economic control over the workers' services. So it will eventually fall back to the primary employer. Now, as I told you, there's a new industrial relations code. According to this code, employer definition is a person who employs whether directly or through any person. So suddenly the issue of contract employees has been taken care of in this current definition of employer. So a person who employs whether directly or through any person, or on his behalf, or on behalf of any other person. So it covers all the permutation combinations possible. And it can be one or more employee or workers. So it can be workers, it can be employees, it could be one, more than one in his establishment. And where the establishment is carried on by any department of the central government or state government, so it covers state government, central government, the authority specified by the head of the department in this behalf, or where no authority is specified, the head of the department, it is very much in line with the previous definition of employer. And in relation to an establishment carried on by local authority, the chief executive of that authority. And of course, it includes first, in relation to an establishment which is factory, the occupier of the factory as defined in the clause N of section 2 of Factories Act. So this is little going in detail, but do understand that the occupier of the factory becomes the employer. And in relation to any other establishment which is not government, not a factory, a person who or the authority which has ultimate control over the affairs of the establishment, and where the said affairs are entrusted to a manager or managing director, such manager or managing director, very much in line with the previous definitions in IDA. And now you see a difference. You can be a contractor is also brought under the purview of the larger employer term, or a legal representative of a deceased employer. So it's a very comprehensive, exhaustive definition of the term employer, which takes into consideration all sorts of employee-employer relationship and all the possible scenarios. Now, some of the key provisions in Industrial Relation Code when it comes to employer. First, under the code, not only the principal employer is liable as an employer, but the contractor who actually hires the worker is also recognized as an employer in his own right. This is something I told before. So IRC for the first time brings in the contractor also as an employer. He brings employer into the definition. He brings in the contractor into the definition of employer. So it retains all the special designation for government and local authorities. So there nothing have changed when it comes to local and government authorities. When it comes to factories, it aligns the term with the Factories Act. So it is broadened. So if you go back, you'll see that in relation to an establishment of a factory, the definition falls back to the Factories Act provision. So that is brought in, and it is also add in a clause which is a legal representative of a deceased employer. Now this was not in the original definition. Now this has been included to cover certain situations where, let's say, individual proprietor dies during the course of a dispute. There is a legal representative. With that, let me conclude today's session as well as the whole week. Let me conclude. If you look at what we have covered in today's session, we have looked at the definition of some of the key terms such as worker, employer, and employee. And if you look at the entire week, what we have covered, we have looked at first how Constitution of India becomes the bedrock for all the labor legislation of the countries. We have looked at some of the key articles in the Constitution of India. We have looked at what are the key articles that empowers various labor law of the country. Then we had looked at how the labor laws of the country have evolved over the course of various time period, starting from British time to the modern day labor codes. We have also looked at the definitions of some of the key terms such as industry, employer, employee, worker, etc. In the next week, we are gonna venture into much more exciting area of labor as well as management of employees. You have now the solid backing of all the fundamentals cleared. Now you are very clear with all the definitions which are required to understand topics of second week. So in the second week, we look into drafting of employment contracts, very interesting topic. We'll also look at what is work, what is employment, what are the various kinds of employment, how the contract should be different as according to different types of employment. Also, we look at certain provisions as well as issues in drafting employment contracts. So next week is all about the initial phase of employment, which is drafting of employment contracts and related aspects. So keep watching this course. Let's meet in the week to the next week of this course. Thank you so much for your patient listening.